Good evening. I welcome you all to the second session of the Lex Veda webinar series. Today we have an eminent speaker, Shri EVVS Ravi Kumar sir, to address us on the topic Framing Substantial Questions of Law in Second Appeals and Court Practice. To give you a brief introduction of the topic, right to appeal from a systemic point of view is fundamental for judicial accountability and to enhance the confidence of the citizens in the judicial system. Additionally, the decisions given by the high courts provide guidance to the lower courts for future cases and also facilitate predictability and certainty in the process of judicial decision making. In India, the right to appeal is a statutory right provided under the Civil Procedure Code. Section 100 of the CPC provides for second appeal to the High Court on substantial questions of law. In a recent judgment of the Supreme Court decided on the 16th of November 2020, namely the Kriparam vs. Surendra Dev Gaur, the Supreme Court held that it is not mandatory for the High Court to frame substantial questions of law under Section 100 if no substantial questions of law exist. So the success or failure of a case depend on the skill of a lawyer to frame the right questions of law. So to clarify further on this issue and to provide guidance to budding lawyers on court practice, I invite Sri EVVS Ravi Kumar sir to speak on the topic framing substantial questions of law in second appeals and court practice. But before that, I request Ms. Kruti Palaga to introduce the speaker to us. Thank you.
Good evening, everybody. I hope everybody is doing great. I would like to take a couple of minutes to introduce our today's speaker to you. Mr. Ravi Kumar is our speaker today. He descends from a family of prominent advocates and is a graduate of law from Osmania University in the year 1993, which he had taken up after his completion of his BCom in the year 1990. After graduating from Osmania University, Mr. Ravi Kumar had begun his practice with his grandfather, Mr. Chitanna, in 1993 at Kakinada, and thereafter he practiced with his uncle, Mr. Ram Gopal. Mr. Ravi Kumar has had a considerable practice in civil courts as well as in labor and revenue tribunals. Mr. Ravi Kumar has also had the pleasure of working under former Justice Mr. Sitaram Murthy while under practice until 1998. Already equipped with his knowledge and experience in civil practice, he was drawn to the practice at appellate jurisdiction of the Honorable High Court of Andhra Pradesh under senior advocate Mr. VLN D.K. Murthy garu. Mr. Ravi Kumar has had some notable cases that he has argued before eminent judges like Justice Durga Prasad, Justice Venkatramana, and many other popular judges. He states that every day in practice is a new challenge. He is adept at subjects of Hindu law and succession, usury mortgages, and many subjects like that, as well as the intricacies of concepts like burden of proof, substantial question of law, and point for consideration, and many such important concepts that have a considerable bearing on one's practice. Mr. Ravi Kumar strongly encourages new advocates to take time to gain experience in civil courts as it lays a strong foundation to one's ability to understand and apply knowledge of procedure and practice. 2 minutes is a very brief time to bring forth to you all sir's achievements. So we're looking forward to your session that we strongly believe will be immensely intellectually enriching for all of us. However, before I let you take stage, sir, I request Senior Counsel Mr. Kautur Vinay Kumar garu to speak a few words of endearment.
Good evening to everybody. This is the second session started by Dr. Swati, who has just finished PG from Bangalore University and also completed CS. And as said last session, that out of academic interest, she has started this webinar and successfully in first session last month. And Mr. Ravi Kumar, well-known eminent civil lawyer of both high courts. In fact, he had participated in the first session as an active participant. I think that is the reason our group immediately is our child as a speaker of this session. And I recollect, I remember without remembering his senior Mr. VLN Murthy garu, eminent civil lawyer, and just now my friend Kruti said that he was with him for a longer time. And so coincidence, two incidents, Mr. Murthy garu and myself and other 4 advocates at a time designated by the combined high court. And another occasion, I think, one first step is we both argued. That was, I think, unfortunately, the last case of Mr. Gurtijar. That was also reported and very, I think that was also in Justice Shashikara Murtijar. A very elaborate judgment on a particular subject. And at the moment our colleague referred Mr. Ravi Kumar, these two incidents, in fact, I could recollect. And, the subject is also very interesting subject, substantial questions of law. It will be very difficult task for any lawyer to frame substantial question of law unless you read and thoroughly preserve this matter, any matter on the basis of from trial court to appellate court. If you know, a trial court adjudication will be on the basis of pleadings and evidence and record, and again appellate court will formulate grounds, and again in second appeal by merging, by verifying these two aspects, primary court judgment and appellate court, we have to formulate one point or one substantial question of law is sufficient for admission of second appeal. And sometimes, even one substantial ground, court may allow us appeal. And again, SLP also, in my experience, one matter, 2025 from Anantapur, I lost second appeal here and different findings recorded by the High Court. At that time, I have engaged a senior most lawyer in the Supreme Court. Of producing the substantial question of law favored by me, he said, one ground I will pick up and I will see that it is detected. Then ultimately we have succeeded before the Supreme Court also. That's why formulating substantial question of law is more important, and that requires, I'm not saying that youngsters are doing more than senior judges. You are all, I think I have seen some of the learned civil lawyers here. I think they will discuss about this practical aspects and practical difficulties also. And substantial question of law, Mr. Ravi Kumar is well known about these aspects, and he will address you well all these doubts. And I hope that the session will be useful for the young lawyers, and also not only young lawyers, practicing lawyers. Because second appeal, when we enter the profession, they say only senior counsels will appear in second appeal. But later, generation together, they know the young lawyers are doing well. They are practically because you are reading well and because of your academic background, you are doing well. But only you require practice. That is sufficient. And on basis of your knowledge, certainly you can do miracles in the profession. I hope that Ravi Kumar will address. Apart from his, I think his education background and also he had experience with eminent seniors, under his eminent seniors. Certainly, I hope Mr. Ravi Kumar, we are expecting more and more from you, and I hope all the best, Mr. Ravi. Over to Ravi.
Thank you, sir. Thank you very much for inviting me to the lecture and also speaking good words about me. Whether I deserve it or not, I don't know. So I'll start the topic. Today's topic of the day is covered by Section 100 CPC. Drafting a substantial question of law in a second appeal is a very big challenge for everyone. Because Section 100 speaks about 5 instances, 5 clauses. Section 101. Favors expressly provided in the body of this code or by any other law for the time being in force, an appeal shall lie to the High Court from every decree passed in appeal by any court subordinate to High Court, if the High Court is satisfied that the case involves a substantial question of law. So, to prefer a second appeal, the memorandum of grounds should contain substantial question of law. That substantial question of law must satisfy the court. Even against a ex parte decree also, you can maintain a second appeal. Am I audible to, sir?
సార్ కొంచెం గట్టిగా మాట్లాడండి సార్ కొంచెం.
Against ex parte decree also a second appeal lies. So for every second appeal grounds, whether you draft grounds or not, the drafting of substantial question of law is mandatory. Without there being a substantial question of law, second appeal will not be looked into by the court, by the High Court. Third point deals with in an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal. Normally, the court, after your argument for admission, what is the ground number where you have raised the substantial question of law? They will not look into the other grounds. They will straight away go to the substantial question of law. Therefore, it is mandatory to frame a substantial question of law for the purpose of second appeal. Then, on extraction of the substantial question of law, the High Court formulates law on its own, or if satisfies the language of the question of law, it will incorporate the same and admits the second appeal. The appeal will be heard on the question so formulated, and the respondent shall be at the hearing of the appeal be allowed to argue the case does not involve such question, provided that nothing in this subsection shall be deemed to take away or abridge the power of the court to hear for reason. The appeal shall be heard on the question of the appeal shall be allowed does not such question, provided that nothing in this subsection shall be take away or abridge the power of the High Court to hear for reasons to be recorded the appeal on any other substantial question of law not formulated by it, if it is satisfied that the case involves such question. After framing the substantial question of law and after the appeal is admitted, the hearing of the appeal, while going through the and while appreciating the evidence, if the court finds that any particular question of law is required to be framed, the court has got every power to frame that substantial question of law and ask the counsel on that particular substantial question of law. Therefore, for drafting of the substantial question of law, you require the entire record. Court judge, appellate court judges, and the document. Normal in the High Court, admission is one challenge. Remember one thing, once the second appeal is admitted, you cannot sit back and relax, say that we are going to succeed because the second appeal is admitted at the admission stage. Once it is admitted, it is not, we cannot expect that it is going to, the High Court will allow the second appeal on the date of final hearing, because the date of admission, one judge will be available, he must be satisfied with the substantial question of law framed by us, but at the date of final hearing, some other judge will be there who have to satisfy him on the substantial question of law. So, the question of law which we have framed must be in such a fashion, whoever may be the judge, who should succeed in the second appeal, that should be the nature of formation of substantial question of law. Now, the Supreme Court, as well as on what ground, normally the court, High Court should be very slow in interfering in the cases where there are concurrent findings of fact. Once both the courts have taken a similar opinion on facts, on question of fact, there cannot be a question of law, and therefore you cannot try a question of law on fact in a second appeal. On the ground, the second appeal will not be admitted also at the existing stage. The Supreme Court in AR 2006, 1975 observed that second appeal is not a trial on facts or one more day in gamble. It is purely a question of law that you have to satisfy the appellate court, the High Court, at the time of admitting the second appeal. And Supreme Court has categorically further observed that framing of substantial question of law is a sine qua non under section 100 that is reported in 2005 Supreme Court 770. Even the disposal of the second appeal on merits without framing of substantial question of law is not permissible. Therefore, substantial question of law has to be framed. The substantial question of law differs from case to case. 4 factors mainly which we have to take care while drafting substantial question of law. The 4 points that are: if the judgment is contrary to mandatory provisions of applicable law, contrary to the law laid down by the Supreme Court, based on inadmissible evidence or no evidence, wrong casting of the burden of proof. Suppose in a suit for declaration of title and recovery of possession, in the written statement, the defendant may state certain facts with regarding to the possession and other things that will not entitle the plaintiff to a decree. He must prove and establish his title over the property, and he has to seek for recovery of possession. If the trial court decrees the suit basing on such alleged admission by the defendant in the written statement without going into the cross-examination or PW's evidence, plaintiff's evidence, then you can frame substantial question of law on that ground, and you can seek for, because it is wrong casting of burden of proof on the defendant instead of the plaintiff. Therefore, under these 4 points are mandatory while drafting a substantial question of law, look into it, and then have to frame substantial questions of law. You can't raise a new plea on facts in a second appeal. Whatever that is available on record, basing on that record only, you have to frame your substantial question of law. You can't raise a new fact, and you can't equal it to a question of law, and you cannot frame substantial question of law on that. The Supreme Court observed that the conclusion based on no evidence not only refers to a total depth of evidence, but also the evidence taken as a whole is not reasonably capable of supporting the finding. In such circumstances also, you can frame substantial question of law basing on that. Normally, in our court practice, the respondent says concurrent finding of fact, concurrent finding of fact. That is not good. You must hear what the other side is arguing, and you must satisfy the court that the reasoning given by the court basing on the facts is true and correct. Both courts concurrently held, this is normal argument that is going to be advanced, that is being advanced by the advocate respondent advocates. Here, both courts held concurrently that will not give the respondent to take a liberal view and contend that there's a concurrent finding of fact. The facts at times may be perverse. Both the courts may arrive the finding of fact. At times it may be perverse. In such circumstances, the appellant is entitled to frame the substantial question of law, how the courts have dealt the issue perversely, and what is the error committed by the courts below while discussing the facts. That also can be a substantial question of law. Of late, the Supreme Court has also observed that the perversity of finding of facts also leads to a substantial question of law. Therefore, one has to take care, because for the appellant it's very easy. For the respondent to sustain, for attempts to sustain the finding of facts, it will be very difficult. So, the substantial question of law, what they frame, how they arrive to the framing of such substantial question of law, has to be looked into very carefully, and we have to take caution. There are two challenges in a second appeal. First is for admission. Previously, the practice after 1976 amendment, the admitting of second appeal has become very difficult, because you have to convince the court on substantial question of law, and after the court convinces the substantial question of law, the court has to formulate that substantial question of law, and it has to be admitted. Now, when I came to the practice, I don't know about Vinay Kumar, Senior Counsel Vinay Kumar Garu. They used to admit the second appeal. The question of notice before admission, notice, this practice was never there. They used to admit the second appeal and they used to get interim orders. So, notice before admission will not give you any credence. Your capacity to see that the second appeals has to be admitted. That is the kind of question of law you have to draft at the time of seeking admission of second appeal. Therefore, you have to frame the substantial question of law very carefully and very correctly. Once you satisfy the court, because the admission time will be very limited for the court. Previously, they used to sit in Friday afternoon, and they used to take up the second appeal, and when we used to point out the relevant question, they used to look into that, and if the court satisfied, they used to admit the second appeal, and if they are not satisfied, they used to dismiss the second appeal. Nowadays, the judges are asking even for admission, as if we have to argue, like a final hearing for admission also. Therefore, nowadays, the drafting of second appeal is also very difficult, and arguing for second appeal for admission is also very difficult. Once the second appeal is admitted, the second appeal has to be argued like a first appeal. You have to refer to the evidence, documents, and everything, and then second appeal has to be disposed of like a second appeal based on substantial question of law. Now there are the substantial question of law is, as I said earlier, it depends upon each set of facts of the case, and the question of law involved in a case is a substantial one or not. The paramount consideration being the need for striking a judicial balance between the indispensable obligation to do justice at all stages and impelling necessity of avoiding prolongation in the life of any issue. Therefore, at the threshold itself, the court can, wherever there is a necessity to look into the substantial question of law, the court will admit. Wherever there is no necessity to admit the second appeal, they will call it they will pass the order. For dismissing the second appeal at the admission stage, no substantial question of law needs to be framed. Only at the stage of final hearing only, after it is admitted based on substantial question of law, the substantial question of law has to be answered by the High Court. There are 2 or 3 occasions where the High Court has disposed of the appeals because formulating substantial question of law by allowing the second appeal. The High Court has remanded. The Supreme Court has remanded for framing substantial questions of law. Your pleading must be supported. Whatever the substantial question of law you are framing, it must be supported from your pleadings and evidence and the documentary evidence. It should not be a new plea or a new thing that has to be developed in the second appeal for the purpose of drafting second appeal. Suppose a suit is filed based on a document. The reading of the document gives 2 opinions, 2 views. The trial court and appellate court has taken one view and dismissed your case. You cannot frame a substantial question of law based on the other view which you have in your case. Because when 2 views are possible, one view has been taken by the court, and when it is not perverse, there is no substantial question of law because the other view will not prevail. Under these circumstances, you cannot frame that substantial question of law in your second appeal based on that document. Suppose the same document, in another case, if the document is not properly interpreted by the court below, and the interpretation given by the court below are wrong, that interpretation gives rise to you to frame a substantial question of law. Based on that, the court can look into that document at the second appeal stage, and it can take its own decision based on the facts circumstances of the case. After 2000 amendment, Section 102 was incorporated. As per Section 102, the suit for recovery of money below less than 25,000, no second appeal lies. Section 102 speaks about that particular aspect. No second appeal in certain cases. No second appeal shall lie from any decree when subject matter of the original suit is for recovery of money not exceeding 25,000 rupees. So the Post Amendment 2002 curtails certain second appeals which are less than 27. It is only money decree, not any other suit. Individual suit, declaratory suit, you can maintain second appeal. But so far as money decrees less than 25,000 rupees, you cannot maintain any second appeal. Therefore, the essential ingredients at the time of drafting, as I have pointed out, are required to be looked into. That is, contrary to mandatory provisions of applicable law, contrary to the law, as laid down by the Supreme Court based on admissible evidence or no evidence, wrong casting of the burden of proof. These four factors are very essential at the time of drafting of the second appeal for framing substantial question of law. The other day when I appeared in a second appeal, the suit is filed for usurpatory mortgage, recovery of the property, 1,000 rupees that was borrowed from the defendant. And the mother created simple mortgage, thereafter he created usurpatory mortgage, that is the plea he has taken. But in the plea when he has taken that usurpatory mortgage, when he has created that usurpatory mortgage, he is silent. But however, during the course of the evidence, he developed that in 77 he borrowed the amount. At that time, he created the usurpatory mortgage, but he discharged that mortgage, but he did not recover the property thereafter. So these pleadings that court has not taken into consideration and concurrently held that this is a suit for usurpatory based on usurpatory mortgage and suit has been decreed for recovery of the property. That recently I have argued and waiting the judgment from Mr. For Honorable Justice Termin. So these are some cases, the findings do not, in the absence of pleadings also there will be some findings in some judgments. In such circumstances, they lead to a good substantial question of law. As far as my understanding, over a period of my training under my senior, the substantial question of law should also at times we have to incorporate the principles of administrative law also. I have seen some of its grounds. He incorporates that administrative law principles while drafting the substantial question of law. When I asked him one particular second appeal, then he explained me how the administrative law will help you drafting second appeal. So this will have administrative law principles also will have some impact on drafting the substantial questions of law at the time of drafting the substantial question of law in the second appeal. Before I conclude, this is a small issue. This is all relevant upon the provisions and the judgments. So the Supreme Court from time to time differ of its opinion. And they say in 2019 SEC page 415, the clause 5 should be given effect by the court only in exceptional cases, not in every case. That's what the court says. In exceptional cases, what the Supreme Court has said. Similarly, 2015 SEC 605. This is a new plea with regard to vagueness of terms of the document. Alleged new plea that stipulation in the family settlement vague and void and unenforceable, being a plea of law can be considered. Suppose Supreme Court said it's a plea of law, therefore it can be considered in second appeal and they have taken second appeal into consideration. This is our own High Court judgment, Justice our judgment, 2026 ALC 198 where the judge observed that a duty is cast upon the court in terms of Section 100 CPC in case of necessity to appraise the material on record afresh and when the interest of warrant such a situation when the findings recorded by the court below are perverse, abstract, did not base on any material evidence, or in leading or due to omission, considered the same, reasons shall be assigned for preferring those substantial questions of law in this matter, extracting the application of such CPC in a given fact circumstance, and particularly having regard to serious contingent advance on behalf of the respondent in the application. Therefore, when there is a serious error in appreciating the evidence and did not consider the material available on record while arriving to the conclusion, then the High Court can certainly interfere in secondary formulating substantial questions of law. Similarly, the Supreme Court in 2021 ALT case 17 Supreme Court observed that we already framed the substantial question of law has to be answered either in one way or the other, and if new substantial question of law has to be framed, an opportunity should be given to the parties and they should be heard on the substantial question of law, and the court has to pass an order basing on the facts and circumstances. The substantial question of law has to be answered by the court. These are the few judgments, the latest judgments. Any second appeal, it depends upon each fact and circumstance of the case. It all depends as to how we have to interpret the point, how the courts have committed error while discharging their duties. These aspects we have to take into consideration at the time of drafting of the second appeal. If finding of fact arrived by the courts below basing on one view and possible view, you cannot frame a substantial question of law by giving other view, saying that this view has to be taken into consideration by the court. But however, this view was not taken, the other view, which is other possible view they have taken, that cannot formulate a substantial question of law. Therefore, my experience and my reading of this second appeal, the section 100, is that a substantial question of law should involve perversity of the judgment, and the findings are basing on no evidence, or inadmissible evidence, and wrong casting of burden of proof. These will give you a good scope for drafting the substantial question of law at the time of drafting the second appeal. A second appeal substantial question of law cannot be framed by reading the judgments of both the courts. We have to invariably read the evidence part also. The evidence, at times a commission report also will make a lot of difference in second appeal. The commission report is a part of record. The commission, at times the court say commission is not cross-examined, commission was not examined, commission report was not marked. All these things they say in their judgment to discredit the commission's report. Commission's report is a part of the record. That what the Supreme Court has time and again observed. And basing at times the commission report will help you to succeed in second appeal also. So commission report will also have a lot of effect. In case where commissions are appointed, the objections filed by the parties, the commission report has to be gone into, and basing on that also you can frame substantial question of law. come to in one field, last court with regard to identification of the property. The Supreme Court responded the matter by appointing an advocate commission, asking the High Court to appoint an advocate commission to decide the dispute once for all. So, the commissioner's report will have that much such importance in suits. It will have lot of impact on the suit. So, if commissioner report is there, commissioner report has to be gone into. At times, you have to file the commissioner report along with your pleading at the time of filing the second appeal itself. Then, any substantial question of law is based on the commission report. The court will go into look into that report, and it will satisfy the commission's report. You will have that impact on the second appeal. With this, I conclude any for interaction. But more interaction will help us rather than giving lecture basing on the judgment.
Thank you, sir. In fact, the whole purpose of Lex Veda having these sessions is to have a discussion on issues concerning various aspects. But actually, there are some questions posted in the chat box, which we will take question by question. But before that, in fact, before we start the question answer session, in fact, there are some other learned advocates also in this group. Merely request the seniors in this group to also share their views or their experiences with other junior advocates in this group might benefit. If any of the seniors in this group want to say a few things before we move to the questions and answer session, it will help the juniors also in this group. May I request the seniors to just share one or two of their personal experiences, because one thing we as juniors notice is, unlike other professions, there is no records of court proceedings. So each advocate's experiences are remaining with them itself without being passed on to the juniors. So this is an opportunity for seniors to share their experiences so that other juniors in this group would benefit. May I just request any of the seniors to just speak 2 minutes, and then we'll go to the question and answer session. If the seniors in this group whom I can identify, if with your permission, if I may just call out, Nasimam Garu is here, who was our first speaker in the last session. So if he could just speak 2 minutes about any of his views about second appeal, then we will proceed further. Nasimam Garu, your audio needs to be unmuted.
Okay, now? There is a full bench judgment for High Court rendered in the year 2004 on the High Court full bench, where the lordships held that right of appeal is a substantial one, and it is a vested right. See, the language employed in that is, it is a vested right. Forum for filing appeal is a matter of procedure. This is the opinion of the full bench. So, when one's right of appeal is declared a vested right, the substantial question of on one ground or other, see, the procedural law as enumerated under section 102, 107, 109, it was truncated first of all. So when once this right is truncated, the judgment of the full bench of our High Court is not at all given effect, and more particularly after amendments taken place in the year 1976, right from Privy Council to our Supreme Court and up to our Supreme Court, up from 1950 to 1976, rendered many a judgment. Nowhere this point was not at all considered.
So now my question is whether a substantial law ends where procedural law begins. CPC is a procedural law. The texture and fragrance of CPC is a procedural law. Being a procedural subject, it cannot truncate the substantial right. So now my question is whether substantial law ends where procedural law begins. This is what I want to pose to Mr. Ravi Kumar. If there is any judgment, if he come across, he can enlighten us.
In fact, the second appeal, the first appeal, substantial right of first appeal has been availed before the lower appellate court. The substantive right, which already been availed before the first appellate court. Now, you are coming to the High Court by way of a second appeal, asking the court. You are not asking the court to look into the facts of the case, only on the question of law. So, once the right of the party under section 100 is curtailed to a mere question of law, the procedural law did not take away the substantive right of the party. You have availed the first appeal remedy. Your remedy under section 43. You preferred an appeal before the district court. You have lost there and you are coming to the High Court. As you rightly pointed out, if the appeal is a substantive right, why we are seeking leave of the Honorable Supreme Court? If we lost the first appeal in the High Court, we are seeking a leave of the Honorable High Court, the Supreme Court. As a matter of right, you can prefer straight away the appeal before the Honorable Supreme Court. Again, its legislature will decide all the issues. Now they have taken away the division bench first appeal under letters patent by virtue of bringing section 100A into operation. The remedy was curtailed. Therefore, the right has not taken away, the party's right has not taken away. Mr.
Yes, I am hearing. During the Constitution, while Constituent Assembly debates, our next Constitution where limited to the intention of the Constitution, or the same is to be treated as a forum for appeals in civil side. That was the discussion. So ultimately they came to the conclusion to keep Supreme Court as an appellate court. So when once appellate forum is there, when courts are time and again declaring that right of appeal, whether it is first appeal or second appeal, right of appeal being a substantial one, is there any judgment which anybody come across or at least considered by our Supreme Court so far?
I'll ask one more question to you, sir. You see the difference between 96 and 100. 96 is a appeal from original decree. Whereas the section 100 speaks appeals from appellate decree. Whether appeal from appellate decree will stand on same footing. Whether it falls under section 2004 full bench judgment. Here, the right of the party is not taken away. The right of the party is curtailed only to the extent of question of law. Because you have lost in both the courts. You have two remedies, trial court, appellate court. From there, the further, now the 102 is brought into picture. 102 captures some appeals, which are less than 25,000 rupees. No appeal, your remedy is otherwise. Section 115 CPC. You have to prefer by way of a CRC, not by way of a second appeal. So, the right of the party has not been taken away. As you rightly said, it's truncated. So the
language employed in 1976 amendment speaks that second appeal shall not be a forum for third trial on facts.
Third trial. That is 2006. That is 2006. Supreme Court 1976. Gurudev Kaur versus Kachi. Gurudev Kaur versus Kachi.
Yes, yes.
So with us, we also have Senior Advocate Ananta Krishna Garu. May I request him to share his views for the benefit of the juniors.
Hello, Pawan and all other friends over the meeting. It's a surprise thunderbolt on my head that I'm asked to speak. I was here to learn things, but I'm asked to speak. Anyway, I'll try to make one or two points which to supplement my friend's statements. First and foremost thing, because you are talking about advice to juniors, I consider myself as the junior most of the bar. May be that as it may. The thing is, we will book which tells that were by the court of law, because every question of law, not question of law, is one thing which you have to fundamentally recognize. So, able to question of law that does not take the status of a substantial question of law automatically. Well, drafting that. Second aspect which I understand to my limited knowledge is, if supposing there is a question, second substantial question of law, but that is answered by the one of the courts, either Supreme Court or High Court, and it is already answered, stands answered, that is no more a substantial question of law because it is answered. So you may not be in a position to raise that as a substantial question, but you may take rescue under that particular judgment. So that is one more thing which is going in my mind. Second thing is, we often quote as one of the standard grounds that this judgment is perverse, this judgment is made on conjectures. These are the standard second substantial questions of law which we try to put it in our drafting. But do we have a material on record, the part of evidence and record, to say it is based on conjecture or it is based on surmises? And what is the difference between surmise and conjecture? And what is the distinction between a question of fact and a question of law, or whether it is a mixed question of fact and law? So these are all the things which we have to have clarity, irrespective of whether we have a brief of second appeal or not. Irrespective of the fact whether we have a brief of the second appeal or not. So, supposing there is a wrong test applied by the court, or supposing the court has based its decision on an absolutely irrelevant fact, or which has totally ignored a relevant fact, this certainly constitutes a substantial question of law. But to prove that, we need to have the material in our possession to see able by the court. Most important aspect is the High Court has no right to grant any interim relief unless it formulates a substantial question of law. So whatever we write is more of assistance to the court, and the court is obligated under, I think, if I am not wrong, 104, whatever the number it is in 100. The court has to necessarily formulate the substantial question then alone it can think of granting any interim relief or not. So these are all, one more thing. If we are looking into a document, how the document has to be looked into is the legal effect of a document. If you are talking about the interpretation of a document, it may become a question of fact. But if you are talking about the legal effect of a document, it becomes a question of law. So therefore, certain things which have to be carefully understood, and reading on section 100 and the judgment would give better light to us on how to frame a substantial question of law. Thank you for the opportunity. I don't know whether I made some sense or not, but certainly I think it is not nonsense.
Yes, sir.
Thank you, Pawan.
From this session, sir. And I also see Mr. Rasti Garu in the gallery, but I can understand he's traveling. Radhakrishnamoorthy Garu, will you be in a position to speak? I'm sorry, I can understand you're traveling, but still out of interest for the subject, you've logged in. Will you be able to speak? Radhakrishna Garu?
Brother, if you don't mind, I'll join in this, not in this part, but I'll join in the discussion part because I'm in the traveling. I'll stay home for the... Please, because I don't want to miss this. That is the reason. Please kindly excuse me. Don't think otherwise.
No, thanks a lot, sir. We could notice that you're traveling. Thanks a lot. Now then we can proceed with the questions that have been raised in the chat box. May I request my colleague Shruti to go question by question so that the speaker can answer the query.
Pawan, before that, one question.
Yes, sir. Hanmantrao Garu.
Yeah, welcome. Sir, Ravi Kumar sir. The substantial questions of law which are framed shall have any bearing on the issues that were framed by the courts below while at the time of framing issues? Should have the bearing on the relevancy, about the relevancy?
Your case depends on the issues. Issue where
Yes.
evidence you will let in evidence based on the issues and other things.
Yes.
It will have certainly bearing on the issues also. That's what it. Suppose if an issue was not framed, but
Yes.
you have let in evidence, the
Yes.
court can give a finding. You cannot say no issue is framed, but you cannot frame substantial question of law on the ground that no issue is framed. Because you
Yes.
have let in evidence, you know the contents of the pleading. In spite of non-framing of the issue, you have let the evidence. Therefore,
That
becomes finding of fact.
That becomes a question of law, substantial question of law.
That will not be what I am saying. Non-framing of issue, suppose if you raise an issue, no issue is framed, no evidence was let in. Still the court gives a finding, then it amounts to substantial question of law.
Yes. Yes.
Suppose if you let in evidence, and if you allow the court to pass a finding based on that particular evidence, you cannot frame that will not form part of substantial question. You cannot frame that is substantial question.
Oh.
I begin reading your question. So, before I start, I'd like to tell everybody this is not it. You can continue to post your questions, and if you feel comfortable, please turn on your video and raise your hands and ask questions so that it can be an interactive session. So the first question we have here, sir, is what mistakes should not be committed by a junior advocate while framing substantial questions of law?
And we have to read both the judgment, material evidence, and the documents that are placed before the body. In case if you find any error in the judgment while drafting substantial question of law, you must ask your client to get that particular document to you if it is not available on record. Without looking into the document, you cannot frame any substantial question of law. At the initial stage, we have to look into each and every paper. Over a period of gaining experience, you will know where the court has committed mistakes and what would be the evidence you can anticipate. But at the initial stage, you will not have that anticipation and you will not have that benefit of reading the bundle. Mere reading of judgment is not sufficient. So you have to read both the trial court judgment, appellate court judgment, as I said, commission's report, evidence, the material available on record. If you cannot frame a substantial question on a fact, then again a question comes: what is a fact? So the fact means whatever the pleadings that you have taken, whatever the evidence that you have let in, the court gives a finding on the basis on that material. It amounts to finding on facts, which we have pleaded, which have given. Once the court has given such pleading, such finding on facts, and the appellate court confirms that finding of facts, we will not have any case in the second appeal. We cannot. While arriving that finding of facts, if the courts are perverse, misreading the evidence, as the senior counsel Anand Krishna pointed out, documents, interpretation of documents, all these things which we have to take into consideration.
The second question as well is from the same person, Subha Vadrivu. What care has to be taken while arguing for admission on substantial question of law?
Admission, you have to take care that you have formulated the substantial question of law. You have to concentrate on that particular question of law, on the relevant evidence, on the relevant pleadings, on the relevant evidence, pleadings, material, what you are saying, you have to concentrate on that. You should not go into other facts of the case. What best case you have formulated, you have to project that first. But you should try to convince the judge on that particular issue. Normally, it's a reversing judgment. The approach of some judges' approach will be different. It's a reversing judgment. What is the substantial question of law? You frame and they'll say they'll. When it comes to concurrent finding of fact, when you frame a substantial question of law, it will be more. You should be more careful and cautious. Normal tendency is the judges will demand concurrent findings. That approach will be there from the other side, from the opposite side, judge's side. So you will face a lot of difficulty in concurrent findings.
So could you briefly tell us what the concurrent findings is?
Concurrent findings is trial court as well as the appellate court. Both courts when have given the same dispute to a case, it's called concurrent findings.
So moving on to the next question, sir, it's from Swati ma'am. Can a second appeal be filed for review of facts by the lower court that either the original court or the first appellate court has failed to appreciate the facts properly?
You can't file it's not a review. The High Court is sitting in appeal on a substantial question of law. If review you have to file for the other provision is available under CPC. You have to go and file review under that provision. High Court will not review the appellate court judgment. Either it will confirm or it will set aside that and it will pass a fresh order. My understanding of the question, correct?
I mean to say, it can always ask the trial court to reconsider or reopen the case and review the facts.
That all depends upon each fact. The appellate court finds, suppose in a second appeal, additional evidence is not permissible. Suppose if you bring in an additional evidence at the first appellate court stage, and the appellate court accepts that evidence and it requires evidence, the appellate court can remand the matter for considering afresh, basing on that material, and ask the trial court to do afresh. Or the appellate court can ask to give a particular finding on that documents only, and can send it back to the appellate court to give its finding. There are two possibilities. One is the entire suit is to be remanded. The other is the court can ask for a particular finding on that document, and they can take it back, and the appellate court can give its own judgment.
Yes, sir.
I just want to ask one question on the remanding back of the additional evidence. So, for example, in a case, particularly if under Section 100, when the matter is pending before the High Court on the second appeal, if any additional evidence has to be needed or any additional documents has come on record by way of, for example, the LR petition was filed, but the other side of disputing the LR petition that they are not LR,
and the document which they are showing as an LR has been disputed, whether the second appeal can view it, can take on record those documents, the High Court can take on record those documents and record findings, or necessarily it has to be remanded to that extent for recording of the findings.
Part 22 Rule 5. Provision student అందులో they say if there is any dispute among the heirs, if you got a legal heirship, the court will send it to the trial court for recording who is the LR, finding, call for a report. The High Court will call for a report and the High Court will then basing on that the LRs will be decided. For that purpose, 22(5) it will not be remanded.
If any new factual aspect come to that notice of the second appeal?
No new facts in second appeal.
No,
even LR can't take a different stand from the original party. They have to stand or fall on the original pleading itself. No new plea can be introduced in second appeal. Only question of law, whether that law it permits you to raise in the second appeal. Based on the facts which you have raised a question of law, it is permissible. Though it is not raised in the trial court, law can be agitated before second appeal. Part 22 Rule 5 student of 5.
At the 20.
వచ్చినప్పుడే చూసేస్తే మళ్ళీ మనకు డౌట్ ఉండదు. Determination of question of as to legal representative. Where a question arises as to whether any person or is not legal representative of the deceased plaintiff or deceased defendant, such question shall be determined by the court. Provided that where such question arises before an appellate court, the court may, before fixing the question, direct the subordinate court to try the question and to return the records together with evidence, if any, recorded at such trial, its finding and reasons therefore, and the appellate court may take the same into consideration determining the question. So, appellate court will not decide that issue.
Even though so for example, even in the first appellate court, I can file an application to say that I want to bring an additional evidence. If I can specifically plead saying that this is the reason which I couldn't produce this document in the trial court. Similarly, can I do the same in a second appeal as well, sir?
There are Supreme Court said it is not permissible, whereas our High Court, Justice Kakastavaru and Justice Sitarajulu, they say that subsequent, it can be taken note of a subsequent event.
Subsequent event, to the extent of
subsequent. But Supreme Court judgment is against that. You cannot, second appeal, no additional evidence is permissible. Because additional evidence is against facts. The facts will not be considered in second appeal. It is only a question of law that will be decided in before the appellate court. Second appeal.
Thank you, sir. Thank you.
May I proceed with reading the questions? I think there are two more questions in the chat box, after which maybe you can directly ask questions. Yes. So the next question is from me, sir. Understanding that there is no definition to substantial question of law, how does one distinguish between a simple question of law and a substantial question of law? And what could be the rule of thumb or a set of guidelines to identify a substantial question of law?
That's what, my lord, and that's what I'm saying, madam. There is no specific definition what is substantial question of law. It all depends upon each fact of the case. The substantial question of law is the reasoning given by the courts below, how bad they are, how the reasoning, how it is contrary to law, how the material that they have taken to considered by the courts below are contrary while giving the findings. each judgment you have to thoroughly read, and then you have to frame this question of law. There is no simple question of law, substantial question of law. It should affect substantially your right in a way. You can put it in that fashion.
So, because I suppose there's a Supreme Court judgment that says that despite the fact that there are so many judgments that have come so far on substantial question of law, no court has been able to identify the difference between a question of law and a substantial question of law, which was categorically stated by the Supreme Court.
You go through this of the judgments where the second aspects have been decided. In some cases, the questions of law that have been framed and allowed and Supreme Court confirmed those, you feel they are the simple question of law, like they are like simple question of law. So it all depends upon the nature of the case. As I told you, usufructory mortgage which I dealt with, there is a distinction whether 61A applies or 61B applies. Limitation. If 61A applies, its suit is barred by limitation. If 61B applies, it's beyond 30 years limitation period. So you have to draw a distinction between those two, and you should make which provision is applicable to your facts of the case. You should make out that, bring into as a substantial question of law, and then you have to frame it and file.
So the next question in the chat is, can High Court admit second appeal merely on equitable grounds? This is from Shreyas Narayan. Can High Court admit a second appeal merely on equitable grounds? On the grounds of equity.
Equity.
Okay.
May I ask one more thing, Mr. Pawar? In the earlier occasion, a question has been raised to Mr. Ravi Kumar with regard to the Ravi Kumar. The gentleman has asked the question. Hello? Am I audible? Am I audible, Mr. Ravi? Ravi, am I audible?
Yeah, now you are audible.
Earlier, posed a question. One gentleman has posed a question with regard to the Order 22, that LR application, and that has been clarified by Ravi. In this regard, I want to tell you only one word. This issue has been dealt by the Supreme Court, Jaladi Sugada versus something rendered by Mr. Justice Ravindran, because that has been decided by the Supreme Court. If my friend has look into the judgment, the entire question posed to Mr. Ravi, what Mr. Ravi has answered it, has been clarified there itself. Because I think Ravi has... Now I want to put a question to Mr. Ravi. Ravi, while narrating with regard to the substantial question of law, I don't know whether he has used a word. It's a good substantial question of law. Rather, don't mistake me. I want to know whether it's a substantial. Is there any distinction in the substantial, liquid substantial? Because this particular word has been used by you. So I thought that I want to clarify because I have not seen that. So I want to know something. Please kindly enlighten me on. Ravi, I think I am clear, Mr. Ravi. Am I audible?
చెప్పండి నాకు వినబడలేదు మీరు అడిగిన క్వశ్చన్ ఇది కట్ అయిపోయి.
But giving lecture, you said you have used a word, it's a good substantial question of law. So, why are this question? Sir, 1 minute, sir. Sir, 1 minute, sir. So, and then I make a note of it. Is there any difference between a substantial question of law and a good substantial question of law? Please clarify, sir. Thank you very much.
No. The only substantial question of law, there can't be any good substantial question of law and substantial question of law.
Okay, because I heard it like that because it was recorded also. So I thought that I want to make myself clear because if there is any good substantial question of law also. Okay, thank you, brother. Thank you very much. Next, please.
Kritik, the chat box complete?
think the chat box is complete, sir. Besides, I think some members are asking for any prominent case laws in the subject matter with regards to this.
Madam, prominent case laws which has given to 2019 SCC 415.
Sir, actually, if you could circulate a note on that, we will circulate in the group so that maybe whenever you please circulate a note on this.
Because Pavan, the second appeal aspect is each fact, each set of the cases. Now I picked up a few judgments depending upon under what circumstances and we can frame substantial question of law. These judgments have picked up. I will send those judgments to you. There are about 7 or 8 judgments are there. I will send those judgments.
Good evening, sir.
Good evening.
Yeah, sir, would it be possible to frame additional substantial question of law once the matter got admitted, second appeal got admitted?
With the leave of the court, you can frame additional substantial question of law. With the leave of the court, you can frame additional substantial question of law.
Thanks. Sir, good evening, sir. This is Murali. With the permission of Vinay sir and all, before I raise a few of my doubts for discussion, may I be permitted to say this? This platform has been an exemplary platform for all of us, for all young advocates like us, to have your seniors experience multitudely, sir, so that we can show our progresses before the adjudicating. So thank you once again, sir, Vinay sir, for giving us your legendary experiences as well the other seniors experiences. It will benefit us in multifold, sir. So having said, sir, if I may permitted, I would raise few of my doubts of discussion. Sir, if I understand the substantial question of law, after hearing this lecture, sir, I understand the substantial question of law to my limited knowledge like this. It arises because it is not something where law should be debated, but on the facts that were adjudicated at the original jurisdiction as well as the first appeal, what has gone wrong with respect to the law? That is to be debated at the second appeal, which forms ultimately as a substantial question of law, if my understanding goes right.
Not only law, but also suppose if the suit, as I told you, if it's a suit for declaration of right and recovery of possession, the burden is on the plaintiff. Suppose the court places burden on the defendant and decrees the suit. It's contrary to the settled law. In such circumstances, placing a burden of proof.
If I may put it in another view, sir, for a moment, in a family kind of matter, because any second appeal arises out of some civil suit or some civil case. Even a family matter is considered to be a civil law, a civil kind of case, a civil kind of adjudication for that case. For example, an RCR petition which is adjudicated at the initial stage, thereafter first appeal, thereafter second appeal. Now all the seniors have been saying time and again that once the facts that have been decided by the the original jurisdiction, thereafter the first appeal, no additional facts should be brought in the second appeal stage. For a moment, in the case of RCR, the spouses get deserted. That is why RCR is filed. Meanwhile, while the adjudication is being happening, as all are aware, like adjudication takes its own course, 50 course of time. During that course of time, if husband gets married to someone else, and if the lady is not in the position to prove it, and at the moment a second appeal arises and there she is able to prove it, if at that point of time, if her facts, if the facts that she is bringing to this honorable court notice, and if it is not accepted, stating that this is the procedure which has to be followed, so we do not accept this fact at this stage. So her right, ultimately, she will be aggrieved in spite of she fighting all the way to the second appeal. Is it not?
Let me understand. Let me have clarity. Normally, family matters nowadays they are going to the family court. They are not coming as a second appeal or first appeal. Only in the aspects of second appeal when it comes, and the wife claims to maintain civil maintenance previously. Now it is given to family court. She approaches the family court. There she will do all the things. The other thing is proof of partition as joint. If there is a joint property between husband and herself, if there is a joint property, then the suit lies to the civil court for her share of partition of the property.
Now, may be permitted to
this under what circumstances is court?
In that kind of case only, if the wife files in a RTR petition or in a judicial separation petition, a separate IA for partition of the properties of the husband.
That's what I'm saying. It again goes to the OP. It goes to SCA first appeal. Because these appeals will not come under second appeal. Family court matters.
Okay. Can I clarify?
There is right.
Can I clarify?
Yeah.
Sir, my name is Murali Krishna. I shortly made it as MMK for the sake of convenience to the Murali Krishna, sir. Please, sir. Sir, please.
Mr. MMK.
Sir, please.
You have asked a question. Of course, Ravi has clarified it. The basic question you want to ask Mr. Ravi is whether a subsequent event during the pendency of the appeal can be brought in the second appeal stage. That should be according to my understanding. Sorry, I am not saying anything against you, but that is my understanding what you opposed to Mr. Ravi. Am I correct?
Yes, sir. With an example of a family.
Of course, don't worry about the example. Don't worry about it. This is the question posed by you.
Yes, sir.
The answer is very limited. In the earlier occasion, Ravi has already informed you that if it is
Sir,
a subsequent event, if it is a subsequent event, in view of the judgment of the AP High Court, Corresponding AP High Court, a division bench consisting of Mr. Justice Prakash Rao and Mr. Justice Hitrajulu, that it can be brought to the notice of the court by showing this is the subsequent event. You can show it. And the court should take it into consideration. Court should take it into consideration and pass orders. There is no doubt about it. If it is subsequent event.
Exactly. Subsequent event.
More
that is the reason I retreated the question posed by you to Mr. Ravi is it possible for a person to inform to the court about the subsequent event which has not been occurred when the suit is pending? Don't think about the family court, all this thing. It is a subsequent event. A party can have the right to place it before the court. Yes, you are having a right to place before the court. But they are a subsequent event. Whether it can be taken into consideration or not, it is the discretion of the court. That we cannot say. But you are having a right to place it before you, subject to my friend says. అంతే అనుకుంటున్నాను రవి, మీరు అన్న క్లారిఫికేషన్.
Yes.
Sorry for interruption.
That is the decision and judgment of the Prakash Rao and Hitraj. Hello?
అది మిస్టర్ MMK.
It has cleared, sir. It is clear, sir. So my question was basically that, sir. Just try to frame it by an example.
More particularly in rent control cases, the default and everything you can bring it by way of additional affidavit before the second appellate court also. Because they have to take note of those facts while granting eviction and other things.
It is 2008 ALT, Mr. MMK 2008 ALT and 2008 ALD. Of course, I can't tell you 1, 2, 3, 4, 5, 6, but it is reported in 2008 ALD.
I will search it, sir. 2008, that is more than enough for me. I will do my search on it, sir. Thank you very much, sir. My second doubt, if the panel permits me, sir, the second doubt is this. I hope I'm not taking much time. I would.
No. You can. It is subject to their file on online.
Sir, my second doubt is this. All through, when we reach to the second appeal stage, merely at original jurisdiction or even at the first appeal stage or any other, for that sake, for any other level, the adjudication happens only on the aspect of facts at the original jurisdiction stage. Now, when the facts are decided, the person who is aggrieved, he only comes to the stage of second appeal. But basically, I keep this questioning myself many a time, sir.
why should a substantial question of law should be framed by the appellant who comes to the court at the second appeal stage? Like sir has said, like Ananta Krishna sir has said, it is on the obligation for the High Court to frame the substantial question of law. Then why should an appellant frame the substantial question of law when he comes there with the facts? Second appeal arises out of facts.
You read 101.
Sir, 101 states this way. Second appeal on no other grounds. No second appeal shall lie except on the ground mentioned in the section 100. Now section 100 speaks about five grounds. On what the second appeal
Section 101. Section 101.
Section 101 in CPC states this. Second appeal on no other grounds. No second appeal shall lie except on the ground mentioned in section 100.
Veda otherwise expressly provided in the body of this court or any other law for the time being in force, an appeal shall lie to the High Court from every decree passed in appeal by any court subordinate to the High Court. If the High Court is satisfied that the case involves a substantial question of law. So, your memorandum should contain substantial question of law. First appeal grounds as you not filing grounds in the first appeal?
I'm filing grounds only at the stage where I'm agreed on the facts. Now, so fact is agreed.
Even in law, the court, you are the loser of the case. Because you are approaching the High Court. Because you lost the matter before the lower court. You are approaching the High Court. You must satisfy the High Court where the lower court went wrong. It is not for the court to look into that and grant a decree for you.
With great respect, sir.
But to satisfy that, the rider imposed this, you have to face online question of law, second appeal will be entertained, not on the facts. Because that rider is not there, even if you challenge a remand order, if High Court, the court, the first appellate court remands the trial court, if you challenge the remand order, you have to face substantial questions for that also. You can't maintain simple CMA. You have to raise substantial questions because how the remand order is bad. Normal agents remand order you prefer CMA, not second appeal. Even for that also you have to face substantial question of law. It's a rider for you to satisfy the court. You can't ask the court look into the other substantial. Once the court frames substantial questions of law and admitted second appeal, at the time of hearing, if the court comes to the conclusion there is another substantial question of law which has to frame, the court will take into that into consideration and it will dispose of the second appeal.
Thank you, sir. Thank you for clarifying on this.
I hope I made clear to all the questioners.
Yes, sir. Thank you so much, sir, for that very enlightening session. I would like to mention, sir, that this second session is a result of the encouragement we got from you. Because of the first session was very interactive, sir. You were an active participant in the first session, and it was like we have evolved. Very organically we have evolved. After the first session, you were an active participant, and then we have evolved to the second session where you've been you've been a speaker and you've enlightened most of us. So I am expecting that our future sessions also evolve in a similar manner, with more and more people participating, and we can have questions. Speakers from our own panel, who are actually interacting right now. So I would really like to thank you, sir, for encouraging us. Because we need people who encourage us to take these webinar series ahead.
Before you conclude the session,
Yes,
I forgot to mention, when the question I have answered, suppose if the first appellate court remands the matter to the trial court, if that remand act has to be challenged, even in that also you have to face substantial question of law. That particular issue I missed to have. So that you should take note of that.
Can I intervene for a minute?
Pawan, can I intervene for a minute?
Yes, sir.
Yes, sir. Yes, sir.
The question posed by Mr. MK, sorry, you are asking Mr. Ravi about this. Having four stages.
The voice is not audible, sir.
Radhakrishna, you are not audible, Radhakrishna.
Hello?
Radhakrishna. There is some disturbance.
Sir, in view of our practice also in the High Court, any case
Ravi,
not see the light of the day. In such a case, in second appeal, in a series of second appeal, if they are admitted, they don't see light of the day.
Am I audible, Mr. Ravi?
You are not audible, sir. You are not properly
I am
audible.
audible, Ravi.
Not audible.
Okay. Then I don't want to trouble all of the people. Please go ahead, because I'm having a small clarification. What Mr. MMK has asked, I want to clarify that.
ఇప్పుడు క్లారిటీ ఉంది చెప్పండి.
Mr. MMK,
Sir,
we are having 4 stages of suit. Am I correct? Suit, first appeal, second appeal, and correct?
sir, I could not hear you, sir. You said 4 stages.
Okay, don't leave it. I'm in the traveling. I'm in the traveling. I should not disturb you. Please go ahead. I'll speak to you personally. Don't worry about it, Nana. Don't worry.
Sir, I shall personally get connected with you on this.
Please, Nana, don't worry, because I'm in traveling. I'm sorry. I have given so much trouble to all the people. I'm extremely sorry. Kindly pardon.
No, it was a privilege having you. In fact, the fact that despite the fact that you're traveling, you still logged in out of love for this subject is actually an inspiration for all the juniors here. In fact, we should thank you for logging in despite the travel you're undertaking. Thank you.
Pawan, in fact, I requested Radhakrishna to participate.
No, we'll definitely have Sir as one of the speakers in the coming sessions. Thank you.
Because we will have benefit
Pawan?
of questions come to us.
Pawan?
We will have resistance.
Ravi?
Yes, sir.
Pawan?
Sir, చెప్పండి sir.
For the question posed to Ravi, that is, what is the difference between a substantial question of law and question of law? Hello?
చెప్పండి.
That was answered in 2007, 5 SCC 669. P. Chandrasekharan versus S. Kanakarajan case, wherein Honorable Supreme Court held that the apex court held that there cannot be any doubt whatsoever that a substantial question of law is different from a question of law. It was categorically answered. So only in order to assist you, I am taking this.
Thank you, sir. We've all made a note of it. Thank you.
Yeah, thank you, sir. As I said, Lex Veda webinar series is a collective effort of the speakers as well as the participants. We expect more such active participation in future sessions as well. After a very enlightening session, we would now all good things have to come to an end. So I'm sure there are a lot of questions coming up, erupting in the minds of all the audience. Probably we can take over the further in the coming sessions and then clarify all those questions. To end it on a lighter note and subject to corrections and all, on a lighter note, I would like to quote a very recent dialogue of Saif Ali Khan and Food Police, where he says, "हमको वो देख लेते हैं जो किसी को नहीं दिखता है." So essentially, a lawyer has to see what others can't see. And as one of the speakers was saying, that you need to read lot of books and lot of judgments, because when you actually read some really landmark judgments, you see that the questions of law that were framed was something which a normal person, a layman wouldn't have seen. So that was something that has come out of really a genius mind. Probably when I read a very good case law, I'm like, definitely this wouldn't have occurred to me. So this is something which has occurred only to a genius mind. So essentially we have to strive something which others laymen, and then because that will help in evolving law. Because two things that I would like to highlight is Section 100 says that the High Court can accept an appeal if it is satisfied. So basically, it is about the satisfaction of the court. So the lawyer can convince the court that there exists a substantial question of law. Then we are as good as we have met the grounds which have been raised under Section 100. And as I say, and there's one more thing that has come up that is said is that we should not debate on already established principles of law. So we have to evolve law. So what is already settled law, what has already been discussed in the lower courts may not be raised in the appellate courts because they will not be accepted as substantial questions of law. So when you think out of the box and come up with really good substantial questions of law, so that where the law is silent, such questions are raised and then answered by the appellate courts, then that will probably become the ratio precedent for future cases. Thanks a lot, Sir Ravi Kumar, sir. We really appreciate your efforts, and I would like Pawan to conclude the session.
Sir Ravi Kumar Garu, thanks a lot once again, and thanks to all the seniors section today. Without your presence, sir, this session would not have been this fruitful, and all of us have learned a lot today, and hoping to see more and more of these sessions. We thank everyone who participated in this session. Thanks a lot.
Thank you.